All right, we'll now hear from the Crown. Mr. Koppler, the floor is yours.
Thank you, my lord. The appellant raises both independence and materiality in relation to the confirmatory evidence of the family members. I'm happy to address them in whatever order the court wishes. As a general matter, it's our submission that the case against the appellant was very strong. We respectfully disagree with the suggestion that the case consisted predominantly of the Vetrovic witness, Mr. Tupan. On the contrary, we rely, and we believe the jury relied, on the many incriminatory comments and actions taken by the appellant that we say led to his conviction. But before I...
That's all circumstantial, though. I mean, clearly the only evidence, the only direct evidence that ties him into the offense is Tupan's evidence. I mean, there was nothing else at the scene. There was nothing else that
There was nothing else at the scene. I think it stands to reason that the jury left with unchallenged, unexplained comments like the victims were casualties of war and they all had to go down, could not help but draw the natural inference that these were not innocent comments and reflected some degree of involvement on the part of the appellant. But I'm not saying...
The family didn't draw that inference. I mean, it took them 2 years to come forward and say anything to the police, because when they heard the statements, people who knew him drew nothing from it at the beginning.
Fair enough. I'm not saying Mr. Tupan wasn't an important witness. Before I get going, though, I just wanted to say the appellant's raised an additional ground of appeal, and I don't want to speak for my learned friend. She's very capable of speaking for herself, but given the nature of the convictions in this case, if she wants to take more time to address that ground of appeal in oral submissions, the Crown has no objection.
You mean the ground about whether his
yes,
connection with the drugs was
exactly
overly...
Yeah, I'm not sure that she had
invested in the trial.
Well, I had asked whether you wanted to argue on that point.
And I understood you to say that you were satisfied for us to rely on your written submission.
That is my position, my lords and my lady, is that if the court has any questions, I'm happy to answer them, but my argument is fully articulated in the written factum.
Understood.
Thank you.
Okay, thank you, Ms. Wade. Mr. Koppler, I refer you to paragraph 9 of your supplemental factum.
Yes.
The second sentence.
Exactly.
Where you seem to be conceding the point raised by Ms. Weed that if the Vetrovic witness learned the information from the other source, it is not independent and does not serve the purpose contemplated by Kayla.
Yes. As a technical matter, as a matter of common sense, and I think fairly as a matter of law, if you can actually say categorically that A learned about X from B, then B's evidence about X does not confirm A's evidence about X. In other words, if you can actually say that the independent witness told the Vetrovic witness about this information, then the independent witness's testimony about that information can't be confirmatory of the Vetrovic witness's information about it because it's not independent. It can still be evidence in the case, but it's not confirmatory in the sense that it's independent. But
I don't think it matters, though, whether the person directly told them or whether you could show, assuming that whether you could show that they'd made the statement either in writing and it had been given to, or they'd make, however, as long as that information was relayed to the Vetrovic witness.
No disagreement. But the important caveat here is that it's only in the very rarest cases we say where you will be able to say that categorically, such that it justifies removing the question from the jury. Because in the overriding majority of cases, or the overwhelming majority of cases, and I think the case law is explicit on this point, these are issues that are supposed to be determined by the jury and not taken from the jury by the judge. And I can refer the court to the Windmill decision, and specifically to the quote from Windmill reproduced at page 10 of the Crown's supplementary factum. The Ontario Court of Appeal held in that case, if there are circumstances such as collaboration among the Vetrovic witnesses, the jury should be alerted to that fact, which will obviously militate against using the evidence of one unsavory witness to support the evidence of another. Now, they're talking about multiple Vetrovic witnesses, but again, it doesn't really matter for the point we're looking at here.
But I think in that case, it wasn't clear what may have been. I think the issue was more there was opportunity, they were talking about it. But as I recall, there was no specific evidence as to what may have been communicated. Is that correct?
Yes, and that's exactly my point. Where you can't say categorically that specific factual information, identifiable factual information was passed from one person to another, and I agree it doesn't have to be direct, it can be passed indirectly, but you have to be able to say that it was passed. Then, as a matter of sort of the general operation of logic, that initial individual's testimony can't be confirmatory. But absent that sort of categorical knowledge, the Ontario Court of Appeal holds, it is for the jury, and I'm back at the quote now, it is for the jury to determine whether an untrustworthy witness's evidence is so compromised by collaboration that it could not reasonably be used to support the evidence of another untrustworthy witness.
So if I could just to assist me, I think the position is, as we've said with Ms. Wiebe, that it's a question of law as to whether evidence is capable of being confirmatory.
Yes.
So if it's clearly not capable of being confirmatory,
yes,
then the judge shouldn't put it to the jury, and if they do, then that's an error of law.
Yes.
Okay?
If you, for example...
If there's an issue, just so I can get my thought out, if there's a factual issue as to what was communicated or whether it was communicated, so you have to make a factual determination, then what the judge has to do is instruct the jury on independence and on the evidence, tell them they first have to find whatever factual issue they have to find, and then make their finding as to whether it's independent or not based on the factual finding. So I think that's how it would go.
So okay.
Do you agree or not agree?
I agree with some of that.
Okay.
As to the first part, yes. If, for example, you have an admission from the Vetrovic witness in cross-examination, well, look, you say you got this from the accused, but in fact, you got this from somebody else. Somebody else told you this information. He says, yes, that's right. Somebody else did tell me that information. Then the judge ought to say, okay, well, in those circumstances, this evidence could not, as a matter of law, be independent. It could not be confirmatory in that sense, and therefore, I won't put it to the jury as potentially confirmatory.
And in this case, he admitted that he they went through, Bercier did, a number of things that were put to him.
Right.
And he agreed, yes, that they talked to him about the farm and Remy and the debts. So he agreed that he was given that information before he made his statement.
Yeah, I tried to set out for you as best as was possible exactly what was put to him and what was played by the police, and that's set out at in the supplemental factum at pages 3 through 6. I'll just double check. Yes. What he agrees he was told is...
Just a second, just so I can find your...
Yep. And particularly the parts relating to Mr. Tupan's interactions with the police are found at pages 5 and 6 of the supplemental factum. Part of my argument, just so that everybody's clear, is that it is very unclear and, in fact, pretty vague as to what exactly was passed between the police and Mr. Tupan. But they definitely played him a part of Mr. Labossier's statement in which he theorized that the appellant tried to convince Mr. Tupan, Mr. Hance, to commit the murder, and about, quote, the money that was used to purchase the house in which Tupan and Hance lived. And they also played one of Ms. Labossière-Clark's statements in which she offered her theory. That is to say, her theory that, and now I'm at pages 3 and 4 of the supplemental factum. That theory, and the only information we have, is that she apparently had a, quote, very similar theory to that of Brian Brisson, and we don't really know what Brian Brisson said, but apparently there was another family member who believed that the murders were done in order to gain control of the farm. And that's basically all we have. So there's this very vague inferential chain where Tupan agrees he was played something from Dan Labossière, in which she said something about what Nicole Labossière Clark had said, in which she said something about what Brian Brisson had said. And our respectful submission, milady, is that, you know, if you're talking about collusion or collaboration or tainting, and I'll get to this in a minute once I get past the question of who makes the decision, but what the decision has to be based on, we say, is evidence. And in this case, it's so vague and so sort of tangential a line of reasoning that it doesn't approach that sort of categorical knowledge that you would need to have in order to say, okay, I'm going to withdraw this from the jury. I'm not going to let the jury consider whether this evidence is confirmatory or not, because it's evident on the record that it's not independent. Generally speaking, that question has to be left to the jury. And I'll give you an example of a case, if I may, that actually makes that point explicitly, and that's the Burrick decision, also from the Ontario Court of Appeal, where the facts are very similar to this, and in fact, we would say the facts are more concerning in relation to the independence of particular witnesses' statements than they are in this case. In this case, as we know, something was played for the Vetrovic witness by the police. We're not really sure what. In Burrick, very similarly, the police arrested one of the parties to a murder and flipped him against the others after showing him statements they had obtained from other witnesses. Okay? Very similar to what happened in this case. As well, they showed him their notes. They showed him the police notes, and they made a number of editorial comments. Not only did they show him this material, they left it with him in a cell. Then, a few weeks later, he entered a plea to a reduced charge and agreed to testify against the others. And the trial judge basically made the ruling that the appellant is seeking to have this court make now. That is to say, this witness is so tainted by access to this material that I can't put it to the jury. The extent of the tainting is incalculable because the police showed him the material before taking a statement from him. In other words, we don't know what he would have said had he not seen this material before giving his statement. Crown appealed. The Ontario Court of Appeal overturned the acquittal and ordered a new trial on the basis that the trial judge had overstepped, specifically because this question of tainting goes to the weight to be accorded to the testimony. It doesn't go to its admissibility. In other words, the jury has to decide what to make of potential evidence of potential tainting and what it means in the context of the confirmatory nature of the evidence as a whole.
In Burrick, is that the case where the judge refused to let the witness
Testify.
testify?
Yes.
So that was a different issue, because here everybody testified. In that case, the judge said the witness can't testify. It was a fair trial issue. It didn't have anything to do really with Vetrovic or the quality of the evidence. It had to do with whether there was a fair trial or not. Is that not the case?
We think the principle is the same, milady, respectfully. The issue is whether the jury or the judge should decide what to make of potential tainting of the witness's evidence. Right? The issue is exactly the same. Can this witness give independent evidence of what happened? In that case, the judge predetermined the question and said, no, he can't, because he's been exposed to this other information, and so we're not going to let him testify. Here, the order that the appellant is seeking is to say he can testify, but when it comes to determining whether his evidence is independent of that of the family members, I'm going to make that decision for you. I'm not going to let you make that decision yourselves, jurors. And we say the error is the same in both cases. And I would refer the court in that regard to the even more recent decision of the Ontario Court of Appeal in Boyce, where again, the Vetrovic witness is arrested. Again, he is originally a co-accused, ultimately agrees to testify on behalf of the Crown, and has exposure to particulars. So in other words, he knows what the statements of the other witnesses have been, same as in this case. The question is, can the other evidence be confirmatory? And the Court of Appeal says, yes, it can. Right? I'm at paragraph 31.
Please.
The appellant submits that the trial judge did not adequately caution the jury as to the frailties of Francis's evidence in accordance with Vetrovic. There were many reasons for the jury to be cautious about relying on Francis's evidence. He had originally been charged with the murder. He had access to the statements of other witnesses, and he'd given an inconsistent version of events. Okay? The appellant submits the matters left with the jury as potentially confirmatory of his evidence lacked the independence required by Kela. Now, in that case, they're only arguing that the instruction needed to be more explicit. Here, the remedy being sought is much more extreme. You're actually saying you can't consider that other evidence as independent at all. The Court of Appeal says, no, I'm going to talk about this later, but they actually go so far as to say you don't need to instruct on independence. And I'm going to get to that point because I think that was the point Justice Burnett was getting at during my learned friend submission. But certainly, they're not prepared to say that the judge should have withdrawn the other evidence from the jury altogether and not let them consider it as potentially confirmatory. They're not even prepared to go so far as to give order a special instruction to the jury. And what you're being asked to do here is far more extreme than that in terms of interfering with the jury's role as the finder of what is ultimately, we say respectfully, a matter of credibility. So the first point then that I wanted to make is that it's only in very rare circumstances that the process should be preempted and the determination of what to make of any potential tainting. That is to say, whether it occurred at all, and if so, what the significance of it is, should be removed from the jury by the trial judge.
You should have difficulty with Sanderson then.
I think depending on how you read Sanderson, then you might that case may be problematic. Yes, I think it is possible, and I can deal with this now, or I can get to it in a minute. It is possible, I think, to read Sanderson in a more narrow way that does not interfere with this general conclusion. I think it is also possible to read it broadly in a way that would place this court in conflict with the Ontario Court of Appeal, and I say respectfully with the decision in Kela, but I don't recommend that interpretation of the case. I think my learned friend has very fairly suggested to you that that is how Sanderson should be interpreted, and we say respectfully that it ought not to be interpreted that way, and that there is another way to read it. But maybe let me just sort of work my way around to that if I can, because I think it may be of assistance if we go through the process, starting with who makes the decision, and then the next point I want to deal with is what do you make the decision based on? And I think that discussion may help with the discussion of Sanderson. So the second point then that I wanted to make is that now we know that the determination of what to make of tainting is a question of weight for the jury. Second point on that is that you have to distinguish between information and statements. That is to say, what is the jury supposed to be concerned about? Witnesses are not tainted by exposure to statements, generally speaking. they are tainted only by exposure to particular facts contained in those statements. As Justice Deschamps observed, in her opinion, in Kella, it's rare.
Dissenting.
Well, we had this discussion yesterday. I mean, it's concurring as to the result, and I don't think she was. I don't think she was in dissent on this point.
Okay.
It's rarely as simple as saying that a witness's evidence is either independent or it isn't. It can be independent as to some matters and not independent as to other matters. And that's another reason why it's the jury and not the judge who has to determine the likelihood and, if applicable, the impact of any alleged tainting, because they have to determine, well, okay, even if there was disclosure to the Vetrovic witness of one fact, does that make everything else that that independent witness said unusable for the purpose of confirmatory evidence? And this case is actually a good example of that.
I would agree with you. I mean, in this case, if all all the information that Tupan had from the family was the motive information and not all the other stuff they testified to, then I would think it would only be the motive information that couldn't be confirmatory. You know, that the Remy was gambling and lost money and was losing the farm. I mean, that to me seems to be the only thing Tupan said that the family repeated, or that the family said and Tupan repeated, however you look at it. It would seem to me that the rest of what the family said, because Tupan doesn't deal with it.
Right, including the rest of what Nicole Labossière-Clark and Daniel Labossière said.
That was my question about motive, as to whether motive, apart from being repeated, whether motive in and of itself is capable of being confirmatory.
Yeah, well, I'll get to that when we discuss materiality, but our submission is absolutely capable of being confirmatory. In fact, it would be, I think, inconceivable that evidence of motive would be withheld from the jury as potentially confirmatory of a witness who said that an individual was involved in an offense. One individual was saying, this is what the accused did, and the other witness is saying, this is why he did it. So they're hand in glove. So getting then to, or following on this point about the distinction between statements generally and the particular facts that would be the subject of an allegation of tainting, the starting point here, and I think this is something that the panel had picked up on earlier, is you have witnesses here who the evidence shows never spoke to each other. Right? There's no suggestion. Mr. Tupan never spoke to the members of the victim's family, and they never spoke to him, other than Daniel Labossière in relation to the connection that he had with them. That makes them prima facie independent witnesses. Now, in order to show that they are not independent, right? In other words, in order to show that even though they never spoke to each other, they're still not independent because information was shared between them by a third party, you have to have evidence of that. Because the evidence is that they never spoke to each other. And evidence, we say respectfully, can only be displaced by other evidence. It can't be displaced by speculation or innuendo. And so what you would want to know in order to make this suggestion that these prima facie independent witnesses are nevertheless not independent is, at a minimum, first of all, what information allegedly went from A to B, and second, what information was then passed from B to C. At a minimum, you would want to know that. Okay, you're making an allegation that even though these witnesses never spoke to each other, they nevertheless communicated through a third party. We need to know, well, what is it that A told B, and what is it that B told C? And then we can determine the implications of those allegations. Do we even believe those allegations? And if so, what do they mean for the confirmatory nature of the evidence as a whole? Ideally, you'd want to know a lot more than that, right? You'd want to know the circumstances of the alleged transfer. You'd want to know the context. You'd want to know how that information was received. But at a minimum, you'd at least need to know what are the actual facts that you say were passed from the first party to the second party, and then the second party to the third party. And here, we say respectfully that evidence was left vague and highly inconclusive. The statements themselves were never put into evidence. And with very few exceptions, Mr. Tupan was not even cross-examined on what parts of the statements were played for him. In fact, it's not even clear which statements were played for him because both of these family members gave more than one statement. So you don't have the A to B, and you don't have the B to C. As I indicated earlier, I tried in the supplemental factum to outline all the places in the record where there were references to either what Nicole Labossière Clark or Dan Labossière told the police in their statements and what the police then said to Mr. Tupan in the course of his interview with them. And as you can see, there's just really not very much there. I think it's fair to say that the police made Mr. Tupan aware of the theory that the appellant was the one that was behind the murders. But surely that doesn't disqualify witnesses from testifying about specific facts that are consistent with that theory.
It's not a question of preventing them from testifying, it's whether that can be used as confirmatory evidence.
Well, sure, but I think, I mean, for our purposes, it's the same thing. You can testify, but you can't use it to corroborate the witness. I mean, I guess, let me rephrase that.
Okay. You understand my point.
Sorry?
You understand my point.
Of course.
Yeah.
Of course. But we say it doesn't disqualify them from testifying about specific facts consistent with the theory, and then that evidence being used to be potentially confirmatory of the theory. Right? There's a difference between a theory and actual facts. That's the point I'm trying to make. Nothing suggests that the facts were disclosed to the Vetrovic witness. And to say that on the basis that a theory was disclosed to a Vetrovic witness, that those independent witnesses' specific facts that they actually have knowledge of that are consistent with that theory can't be relied on as confirmatory, we say is completely inconsistent with the long line of cases out of the Ontario Court of Appeal in Windmill and Burek and Boyce. Because that's not the approach that the Ontario Court of Appeal has taken.
My recollection was that the only things, it seems to me, that are at issue are Tupan's statement that Labossière said he was mad because Remy was gambling and running up debts. I think, as we said, and maybe going to lose the farm or something. And was that not put to him by Mr. Bercier at some point? Or what, did Mr. Bercier not ask him whether he was told that by the police?
Let me find you the.
I thought those details
the references
were given to him.
Okay, I think volume 6.
Oh, it's it's volume 6. It starts at page 66.
Okay.
January 25th, 2012, whatever that is.
I'm sorry, lady, say again?
January 25th, 2012, whatever.
Yes,
volume it
yes,
is.
yes.
Volume 6.
Yep. Okay. So all the paragraphs, and right at the bottom of the page, where they mention Jérôme Labossière's name, they're talking about Jérôme Labossière and what they think he did, and they're telling you all of this before you give your statement. Is that right? Yes. So as I say, in addition to telling you their theory about Jérôme Labossière, and their theory was really, and correct me if I'm wrong, but their theory, as they told it to you, was that Jérôme Labossière had convinced you and Mr. Hans to commit these murders. That was their theory they told you about. Is that right? Yes. Okay. So as I say, fair to say they told him this is the police theory of the case. The appellant was involved, and he got you to do this. That's their theory of the case. And in addition to telling you that theory of the case, they also played for you audio recordings of statements they'd taken from people they'd interviewed for this investigation. Is that right, sir? Yes. You listened to Dan Labossier's statement. You said that in your direct examination. It's in this transcript. Yes. Again, transcript never put on the record, right? So we don't have any actual data as to what exactly was played for him. But they put to him, they played for you Brian Brisson's statement. They played for you Daniel Labossier's statement, and they played for you Nicole Labossière-Clark's statement. And then there was also an individual named Koakevich. I think they also played part of that statement as well. Now,
when you get to page 71, they actually get to some more detail. They talk about Brian Bryson's statement and Nicole's statement.
Right. And I think the exchange that you're talking about actually, milady, is at the bottom of page 70. In addition to the theory from the police that Corporal Hall relays to you during the course of this interrogation, he also relays to you by listening to these statements the theories of all the family members as to how this happened. Is that right? Yes. So you get to hear Daniel Labossier's theory that Jérôme tried to convince you to commit the murder. Is that right? Yes. And you're aware of comments about his theories about the money and how that money was used to purchase the house that you bought. Is that right, sir? Yes. And when you listen to, and again with Nicole Labossière-Clark, when you listen to her statement, she has a very similar theory. Is that right? So again, this is my point. There's no facts. Right? What he admits is, I heard some statements that related some theories. But the suggestion...
the theories were that that there were financial difficulties with the farm, and his belief was to get control of the farm. That was the theory, and that Nicole had a similar theory, that is, about financial difficulties, and that Labossière wanted to get control of the farm. So that was the theory. I mean, there are some facts.
Well, I mean, okay. I would characterize those as theories, but I take your point that basically what they said to him was... If
you say just theory, it could be that he was going out with his girlfriend, or that he said his mother wears army boots. I mean, the theory was more specific than that.
It's a particularized theory. But there are no actual facts alleged. It's still just a statement. Like, we think, and the family members think, you did this offense because he hired you to do it, because he wanted the farm, and he wasn't happy with how Remy was running the farm.
But that's what a motive is. I mean, a motive is generally a theory as to why someone does something.
Well, I agree, but the evidence of the family members that's pointed to as being independent is not their theory. They didn't come to court and say, we think that the appellant did this offense because he wanted to get control of the farm.
Well, they did say that. They said other things, but they said that as well.
Well, no, I don't believe so, milady. And certainly their opinion, even if they did offer it in evidence, wouldn't have been useful. What they said was that what they did was provide testimony as to specific facts. On such and such a day, the appellant said this. I was in this place, and he said this to me. After the murder, he tried to buy out all of the beneficiaries of the farm for a fraction of what the farm was actually worth. After the deaths, the appellant produced a will purporting to leave everything to him and his son. The appellant referred to the, well, that's actually not from Nicole Labossière-Clark, so I'll leave that comment out. But my point is, I think the court probably takes my point. There's a difference between telling somebody, look, you know, in the course of an interrogation, we think this is our theory, and so does the rest of the family. They think this is what happened as well. That's not the same as coming to court and testifying about particular facts. And I think it's worth noting in that regard that the facts are what the trial judge referred to in the charge as being potentially confirmatory, not the theories of the family members as to who was responsible or why the murder was committed. Getting back to...
But I guess then you could argue that what Tupan said were facts. I mean, he said Labossière told me that. He was angry with Remy, that Remy was gambling and he was losing the farm. I mean, I guess you could argue that those are facts too then.
Yes, and I think, and those are. Those are.
Yeah.
just getting back to this idea of why it's important that judges don't just sort of fundamentally remove this issue of what to make of potential tainting from juries. And I appreciate I'm sort of getting a little off the chart here. But I think it is appropriate to consider the implications of that kind of a ruling for other cases apart from this one. And I would respectfully submit that that's what the Ontario Court of Appeal had in mind when it has consistently ruled that these matters should be left to the jury. It's not at all unusual for a group of accused to be originally charged and then for one of them to enter into an immunity agreement with the prosecution, as in Boyce or as in this case. When that happens, each of the accused will have been interviewed. The police will likely have asked pointed questions pressing their theories of the case. They may have referred to some of the other evidence in the case, and the witness may even, depending on how far things have gone, have received disclosure of particulars. If that means, as a matter of law, that none of those other witnesses can then be used to confirm the evidence of the Vetrovic witness, our respectful submission is that would have a very chilling effect on the administration of justice, and particularly in relation to the successful prosecution of gang offenses, criminal organization offenses, offenses like this where there is a sort of a premeditated plan put into effect. Surely we say the answer, rather than preempting that process from even happening, the answer is to allow the parties to put all the information before the jury and let them decide, let them determine the extent to which any tainting affects the confirmatory nature of the evidence.
But then the jury has to be given that instruction.
Well, I'm going to get to what exactly then that leads to the question of the charge, but I think first I have to convince you that it even gets to the jury. But I think, if you allow that to happen, right, if you let it go to the jury, then the jury can take into account things like the fact that while Mr. Tupan's evidence here was consistent, no doubt, with that of the family members, and this is something that Justice Beard has been coming back to a couple of times, there's really almost no factual overlap between what he testified to and what they testified to. Right? They discussed almost entirely different areas, which is not surprising considering that they had entirely separate dealings with the appellant. And that suggests, and I think this is a question that has to be left to the jury to determine, but it suggests that even if there was some sort of exposure of information to Mr. Tupan on April 30th, 2008, that it had nothing to do with the evidence he provided 4 years later on January 5th, 2012. And we say respectfully the jury has to be able to draw that conclusion. The judge can't take it away from the jury by saying...
It has to be open to them.
Sorry?
It has to be open to them.
Yes, it has to be left open to them to determine, well, what do I make of this evidence? You can't just say, well, once there was the specter of contamination or collusion, and I think this is the suggestion that was made by the appellant, then that evidence, you can no longer have confidence that the overlap is due to the fact that they're telling the truth. Well, we say, sure you can. It's not predetermined that once there has been some sort of exposure that necessarily means that you can't rely on this evidence as confirmatory. Jeremy Tupan's interview with the police was 4 years before his testimony. And he testified about things that were almost completely separate from what the family members testified to. To say that because they told him something about what the family members had said, therefore, you must conclude as a matter of law that he was just saying what the family members had said and just adopting that and turning that into his evidence is an enormous stretch that the jury isn't required to find. And we say, in fact, the evidence really supports the opposite conclusion. But they can only get that far if you let them ask the question. If you remove the question from them, then they never get to make that determination. Okay, so how about Sanderson? Strictly speaking, it's not an issue in this case, we say, because you can read it as standing for the very narrow proposition that where there is an issue as to whether or not evidence is independent or not, then the Vetrovic witness's testimony, standing alone, in the absence of any other evidence, cannot serve to determine the question of its independence. That's the narrow holding in Sanderson, right? And my learned friend went through the facts. We can go through them again briefly, but basically the evidence was in the newspaper. It said, put to him, look, well, did you see it in the newspaper? He said, no, I don't read the Free Press. I only read the Sun, or whichever way it was. And the court says, well, look, the only way you can decide whether you believe him about whether he read which newspaper he read is if you believe him generally. And the fact that you're using to support believing him generally is his statement that he only read this newspaper and not the other newspaper. So it doesn't add anything to his credibility, and so it's a circular, right? So essentially, it's just an observation of the common sense principle that a witness can't bootstrap their own credibility. Here, Mr. Tupan was never asked, where did you get this information that you're testifying to? Did you get it from the family members, or did you get it from your conversations with the accused? It was never put to him, where does this come from?
But isn't that the question of did you get this information from the Free Press? I mean, if we're told in Sanderson that it doesn't matter what he says because it becomes bootstrapping, then it doesn't matter whether he was asked or not, does it?
Well, that's the broad way of reading the case, right? In other words, you could read it as saying, look, once there is a potential avenue, once there's evidence of some other avenue in which the witness could have discovered this information, then that's the end of the analysis. Right? You can't ask the witness, well, you know, did you get it from this place? You can't.
You could ask. It's just that the answer would become a Sanderson answer.
Right? Yeah, you can ask
it
them.
Wouldn't
it
help.
Doesn't mean anything. You can't weigh their answer. You can't look at any other evidence to determine how likely their answer is. We think that's, well, that's a very problematic position, I think, for this court to place itself in. Because just because a witness has other avenues available to gain information doesn't mean that the judge should conclude on the jury's behalf that that's how he got it. Right? Look at Boyce. Look at Burek. Look at any case where a number of people are arrested and then one of them eventually enters into an immunity agreement.
I guess the issue isn't whether he got it from there. The issue is whether it's tainted because it's possible that he got it from there. Once you prove if you prove that there was another avenue available, then the only thing it affects is the independence, because you can't say for sure that he got it from the source that you want to say he got it from, in this case from Labossière,
right,
because he could have got it from somewhere else. So, I mean, that only raises the reliability issue. It doesn't, the independence issue, it doesn't mean that the evidence isn't admissible.
It means that it can't be used as confirmatory evidence. Well, that's not the position of the Ontario Court of Appeal. And we say respectfully, it's also not the position of the Supreme Court in Kela.
Was Sanderson overtaken by Kela?
That's a good question. I think it is possible also to say that in light of Kela, and I think in light of the decisions that have followed Kela, like Boyce in Ontario, it may be time to, if not revisit the narrow holding in Sanderson, at least revisit or clarify that it did not mean that all you have to do in order to knock out the potentially confirmatory nature of evidence is show that there was some other way that maybe the Vetrovic witness could have got this information. I'll give you another example, and this is going to be sort of repetitive for Justice Beard because it's a case that we argued yesterday. But there's the same allegation is made, that is to say that there's a concern about indirect passage of information from one party to another. In that case, it's not the police, it's a friend that two witnesses have in common. Okay? One witness who knows about the murder because he was involved in it is at a party, and he discusses the murder at the party, and he admits that it's possible that a third party, a friend of his, might have overheard the conversation. Then that third party has a conversation with the Vetrovic witness in the police station before he decides to give evidence because they're friends, and the third party has also entered into an immunity agreement on his own matters, and so he's a guy who he can go to for advice. So they have this conversation, and the suggestion is, aha, right? The middleman maybe knew about the information, and maybe he passed it to the Vetrovic witness. So there's a possibility, an avenue open. But surely it defies reason to think that a homicide investigator who's, I should say that the conversation takes place in the police station with a detective sitting next to the Vetrovic witness. Of course they're not going to let him discuss the actual murder that he's about to give a statement on with a third party who's going to tell him information about it. That would never be allowed. It would make him a much less useful witness. And to say that the court can't consider that, or we say the jury can't consider those facts to say, well, how likely is this really? Because all you have to do is establish, the information wasn't hermetically sealed in the, with the family member. There was a possible way for it to get to the other witness. That can't be all you have to do in order to say that now it's not independent, it can't be considered independent, it has to be removed from the jury in that regard. It's unrealistic, and it's inconsistent with the other cases. And I think it's actually inconsistent not only with Kayla, Chief Justice, but with your own decision in Ponce and Tavares. The case of Ponce and Tavares, and this is at tab 2, by the way, of the appellant's authorities.
That dealt with mostly materiality requirement, not the independence requirement. It did deal with confirmatory evidence.
It also dealt with independence. There's a few little comments in it. Particularly, if I can direct the court to paragraph 77.
Of Ponce?
Of Ponce. Tab 2
Just a minute, please.
Of the appellant's authorities, not the Crown's authorities. Paragraph 77. Counsel for Ponce submits that reference to the knife as confirmatory evidence was an error. He asserts Simeo is the Vetrovic witness in question. His evidence at trial on the type of the knife he allegedly saw with Monkman was inconsistent with his statement, and his evidence at the preliminary inquiry also inconsistent with descriptions of the knife given by individuals at the nightclub. By the way, this, I don't want to get off topic, but I think this actually speaks to the argument that my learned friend made about whether the fact that there's an inconsistency in the evidence means that it can't be material. And I think the court deals pretty clearly with that and says, yes, it can. But here's the part I'm referring to. He says the use of the knife at the nightclub was not confirmatory of the presence of the knife in Monkman's hands in the vehicle, or that it was shown to Simeo, noting that the fact that a knife was used could have been ascertained by Simeo through other sources. Okay, so the point here is Simeo says in the car on the way to the incident, the accused pulled out a knife. I saw him with a knife. And the judge puts to the jury, you can consider this as confirmatory evidence because other witnesses described the accused with a knife later. And the appellant argues, seriously? The deceased was stabbed to death. Everybody knows he was stabbed. that's not confirmed. That's not independent evidence saying that the guy had a knife. He could have got that from anywhere. There's nothing to lead you to believe that he got it from the fact that he was in the car with the accused, as opposed to he knew that the deceased was stabbed, which is the reason why we're all here. Right? In other words, that's Sanderson. Right? There's another avenue available by which he could have acquired this information. Therefore, it's not capable of being confirmatory, should not be left with the jury as potentially confirmatory. Paragraph 80, court says no. Monkman's counsel admitted to his using a knife to stab the victim. The fact that a knife was used to carry out the attack shortly after all the four men arrived at the scene is a piece of evidence which could be viewed by the jury as consistent with his evidence he was shown a knife by Monkman in the back of the vehicle a few minutes before. It is independent of Samael. Okay, and it is with respect to a material and relevant point. But the key point I want to make here is, so
Ponce counters Sanderson to a certain degree.
yeah, well, just not that it counters it, but that consistent with everybody else who's looked at the issue, this court seems to have proceeded to interpret Sanderson only as standing for the narrow proposition that a witness can't bootstrap their own credibility, and not for the sort of more general proposition that all you have to do to knock out a piece of evidence as being potentially independent is show that there's another way that maybe the witness could have got it. Rather, this question goes to the jury. And that then leads me to the next question. Okay, well, assuming you're right about that, and this is a question for the jury, what do you have to tell the jury? And this is the point that Justice Burnett was getting at. Again, we say there's assistance from the Supreme Court in Kella.
In?
Kella.
Kella.
Kella. What the majority says is that it's certainly preferable to instruct on independence. That is to say, tell the jury what it means to be independent and warn them that it has to actually be independent before it can be confirmatory. But it is not critical. It is not necessary for the charge that happen.
If you can find support elsewhere.
Yes.
Because they said although the judge didn't talk about independence as independence, in fact, they found that had been put to the jury in other ways.
Exactly. What matters is, the bottom line is not whether you talk about independence per se, but whether the charge in conjunction with the proceedings, okay? And that includes submissions. I'll have a little bit more to say about that. But whether the totality of what the jury is told outlines the substantive concerns as to potential tainting and why the defense says the evidence in question is suspect. Okay? So you don't have to have a special instruction about independence. What matters is that you tell the jury, why do you need to be concerned about this evidence? Right? What's the problem with this evidence? Whether the judge treats... Oh, sorry, I'll get to that point later. If I can just refer you to paragraphs 55 and 56 of Kella. That's where Justice Fish makes this point explicitly. Middle of the paragraph, the trial judge repeatedly alerted the jury to the possibility of collusion and the motive that Stein and Sandoval had to lie. For example, the trial judge, in reviewing the evidence of the impugned female witnesses, reminded the jury of the defense position they collaborated with Stein and Sandoval in concocting their stories. The trial judge also reminded the jury of Sandoval's admission that the police had early in the investigation leaned on him and accused him of masterminding the murder. In reading the charge as a whole, I am persuaded the substance of a proper Vetrovic caution was communicated adequately, albeit imperfectly, to the jury. They were told the danger of relying on the unsupported evidence of Stein and Sandoval and directed to the types of evidence in which they might find confirmation of that evidence. You don't have to actually tell them, okay, this is what it means to be independent, and these are the concerns that specifically attach in that regard to particular evidence. What matters is, do you discuss the evidence? Right? Do you actually tell them, here's the evidence, and this is why you need to be concerned about it? The Ontario Court of Appeal, following Keller, reaches the identical conclusion in Boyce. Okay? Again, I referred you to that case earlier on the point about whether it goes to the jury at all, but the case is actually about what you have to say to the jury. And the complaint in that case was, the appellant submits that the trial judge had to make it clear to the jury, I'm at paragraph 31, that Francis tailored his evidence to the statements of the other witnesses, and that to be confirmatory, the evidence had to be independent of Francis. So exactly the sort of specific instruction that you're being asked to provide here. Ontario Court of Appeal says no. No. As long as you sort of do the four, I think Chief Justice, you referred to it as the Kella Four.
Like Paul before, yeah.
Okay. As long as you do that, and as long as the jury at a substantive level is made aware of the concerns, that's all you have to do. This is consistent, and again, I don't want to get too academic here, but this is consistent with the whole line of case law starting with Vetrovic and moving on from there. It's not supposed to be about fitting evidence or fitting the charge into a sort of a pigeonholed box. It's about ensuring at a substantive functional level that the jury appreciates the strengths and the weaknesses of the evidence before them. Okay, so that's why the court declines to say that you needed that special instruction. But they actually say more than that. They say, in the context of this case, I'm at paragraph 36.
Of what?
Of Boyce.
Do you know where the Boyce was appealed?
Sorry?
Do you know where the Boyce was appealed?
Let me check. I believe the answer is no.
It doesn't matter. Don't worry. I can find out later.
Okay. Okay, so paragraph 36. Middle of the paragraph. In the context of this case, where the likelihood of collaboration or tailoring was an obvious issue, the failure of the trial judge to expressly refer to independence was not fatal. And it actually refers back to Kella, because that's exactly what the court said in Kella. You don't have to have the charge refer to it explicitly if it's a big issue in the case, because it's not about sort of ticking off all of the right boxes in the charge. The analysis is functional. Did the jury actually appreciate what they had to do? That's the question we have to look at. And in that regard, first of all, we say that the tainting concern here was specifically highlighted by the learned trial judge for the jury. That's at paragraphs 14 and 15 of the supplemental factum. But the quote, that is say the quote is reproduced there. It's from pages 151 and 152 of the appeal book. But Chief Justice, you'd referred to this during my learned friend submission. Right at the beginning of the discussion of Jeremy Tupan's evidence, the judge says, there were a number of areas in his testimony that in my view should cause you problems in accepting much of his evidence. And then she goes through them. Okay, so it's already teed up as, here's a concern that you need to worry about. One of them is, next, when Tupan was originally arrested on April 30, 2008, he was interrogated by the police for some 5 hours without giving a statement to police. As counsel have pointed out, in that 5-hour period of time, the name of the appellant was mentioned by the police on at least 57 occasions. The police repeatedly went over the theory as to who was behind the killings, and numerous audio statements involving evidence were played to Tupan. So she specifically tees it up for the jury as an issue that they need to be concerned about. And the suggestion here is, well, she could have done more. Well, obviously she could have done more, but that's not the test. The test is substantively, was the jury misled? Right? Did they appreciate that this was an area that they should be concerned about, or an area that they had to consider? Then, after she says it would be dangerous to rely on Jeremy Tupan in the absence of some evidence that supports what he relates, she says, you may find that there is some evidence that confirms or supports some parts of his testimony. Well, I might express my opinion, she says, where I believe there may be confirmatory evidence. This decision is entirely up to you. It is for you to say whether this or any evidence supports or confirms his testimony and how that affects whether or how much you will believe of or rely on his testimony in deciding this case. So it's very clear, first of all, that she says this is an area that you need to be concerned about. And second of all, it's not my opinion that matters. So if I refer to something as being potentially confirmatory, who cares? You're the one who has to decide. It's your decision that matters. Then, in paragraph 16 of our supplemental factum, Appeal Book, page 164, she says again, in discussing the Tupan's evidence in relation to the appellant's involvement, she says, again, bear in mind the cautions I have earlier expressed about Jeremy Tupan's evidence and as to how much weight you put on his description of these conversations. So there's an initial warning. She specifically refers to the playing of the statements. She tells them it's your decision that counts, and then she comes back to it a third time and rewarns them again later in the charge. Now, that's just the charge. That's not even getting into what defense counsel said about all of this during counsel's submission. That is discussed at paragraph 29 of our factum. And it's set out at volume 9 of the transcript, pages 20 and 21. But this was an extensive subject of comment by defense counsel for the jury. He argued vigorously that here's how it went down, jury. First thing that happened is the family members went to the police with a bunch of what he called theories and biases. And then the police poisoned the interrogation, that's his words, poisoned the interrogation of Tupan by, quote, feeding these biases and theories to Jeremy Tupan during the course of his relentless 5-hour interrogation, and it's only after this relentless interrogation that Jeremy Tupan broke down and told the police exactly what they wanted to hear, end quote. So if there's any concern about the impact that having been played these tapes might have had on Jeremy Tupan's evidence, there's no question that the jury was well aware of it. The defense lawyer, well, I don't want to say, shoved it in their face, but made them extremely aware of these concerns. Okay? He referred explicitly to the fact that the family member statements had been played, and then he told the jurors that Tupan's evidence was, quote, not independent, in the context of it having been acquired after he'd been played these statements. He says, Jeremy Tupan's evidence is not reliable, and it's been poisoned by the way the police conducted their interrogation. So in the context of all of that, we say respectfully that there's no reasonable likelihood that the jury failed to appreciate the concerns with Tupan's evidence, and particularly no concern that they failed to appreciate whatever dangers were raised by the fact that the police had played some unidentified sort of vague parts of 2 out of the 6 family members' statements. And so according to the standard for intervention that's been set by Kela and by Boyce, we say that there's no basis for appellant intervention on that score. Now, that leads to the application of the curative proviso. But Chief Justice, did you have a question?
No, I'm fine. Thank you.
That deals with independence. So you're going to go on and deal with materiality?
Yes, although I did want to get to the curative proviso first, specifically as relating to independence, just because Sanderson speaks precisely to that point. And if I can, Milady, we would respectfully submit that, we take a very different reading of what Sanderson says about the applicability of the curative proviso than my learned friend. And in particular, we rely on it's at tab 3 of the appellant's authorities, and I believe it's paragraph 68.
The appellant's authority?
Yes, appellant's authorities. Tab 3.
Lepage?
Sorry?
Lepage?
No, that's the respondent's authorities.
Oh, I'm sorry.
Sanderson. It's Sanderson at paragraph 68.
Sanderson, paragraph 68. Middle of the, well, actually, first line of the paragraph, An error such as occurred here would not be fatal in many cases where there is other evidence, perhaps overwhelming evidence, pointing to guilt. Okay, we have some submissions on that, but the key point has to do with the issue of the Vetrovic witness, and that's at the bottom of the paragraph. If there really were other examples of evidence supporting Stevenson's credibility, the identification of the two matters discussed in the charge might not be so critical, but there are no other circumstances that have been identified that could truly be supportive evidence. In other words, if there was anything else you could point to support this Vetrovic witness, then we wouldn't be so concerned about having mistakenly referred to this evidence as independent when it actually wasn't. So the question is, was there other evidence capable of supporting the evidence of Mr. Tupan, the Vetrovic witness in this case? And we say respectfully that there was significant other evidence not stemming from Nicole Labossière-Clark or Dan Labossière that was capable of supporting the credibility of the Vetrovic witness. It's outlined at pages 20 and 21 of the supplemental factum, but just to briefly go through it.
Just a second, please.
Sorry, I should say, did I say paragraphs? I meant pages.
You said pages.
You said pages.
I did, okay. Just to briefly review some of this. Gary Clark, right, married to the appellant's sisters, testified that prior to the shooting, the appellant said 3 or 4 times that the victim, Mr. Remy Labossière, was not looking after the family farm finances very well, and, quote, that he should be shot. Well, that's certainly capable of confirming Mr. Tupan's evidence that he shot the victims at the behest of the appellant. Bernard Thomas Grenier corroborated this, testified that the appellant had also complained to him about...
Except, if it seems to me that if the evidence was Tupan got that information, but I guess this is where it gets to the dual aspect of the information, because one is, does it confirm because it's the same statement repeated regardless of content, or does it confirm because it's motive? Because it seems to me that if Tupan got the Remy's wasting all the money and he's gambling and the farm is going down, whatever it was, whatever the wording was, if he got that from a tainted source, then the fact that untainted sources said the same thing, I think doesn't help it.
Yeah, I take your point.
But if it's evidence of motive, then
well, I think that I think what the court's saying though in Sanderson is, look, can you get outside this particular tainting? And here we say you can. But I take your point. Yes, if A tells something to B, and B gets it from A, it's not independent. Even if a whole bunch of other people say the same thing, that doesn't make it independent. I take that to be the point you're making, and I agree with that.
Okay.
But look at the other comments. Look at the deceased got what he deserved. They all had to go down Friday night. Look at the comment about the nature of the offense. This is Nicole Labossière-Clark again, but not, again, no suggestion that this was passed on to the witness. At one point, they're speculating about maybe some other individual was connected with the offense, and the appellant says, well, it would be a shame if the wrong person got blamed for this, plus he would have smelled like gas. And at that point, they had no knowledge of the nature of the fire. Certainly that's capable of corroborating the evidence of the Vetrovic witness. Then his conduct following the offense, producing the second will, trying to buy everybody out. Sean DeRoche testified that he asked the appellant, what's going to happen if I refuse to sell you my share of the farm for a fraction of its value? Am I going to get a bullet in the head? The appellant says no comment.
I find that one a little hard to.
Well, look, you have to see it in the context of everything else, though. I mean, on its own, sure, but combined with all of the other comments, if I was responsible, they wouldn't be able to pin it on me. I mean, we say there's a pattern here of sort of not quite bragging, but certainly not quite denying that he was involved in this. The day after the murder, he's in a hurry to get the site of the murder bulldozed. He wants to get everything buried, get it all covered up as quickly as possible. This comes from Paulette Desrochers' evidence, Volume 4 of the transcript, page 121. Paulette Desrochers again, January 27th, 2005, asks him directly, "Did you have anything to do with what happened at the farm?" He rams his fist on the table and says, "They're casualties of war." So, I know, and I should note as well, that's just the evidence that makes it into the charge. As the Chief Justice, I think, quite accurately points out, the judge left out all sorts of other potentially confirmatory evidence on the ground that it would be overly prejudicial to the appellant. That doesn't mean that it wasn't there, and that doesn't mean that you can't look at it in deciding whether the curative proviso applies, even if you find that the judge either should not have left the whatever you decide came from the statements of Nicole Labossière-Clark and Dan Labossière and made their way to the witness, Mr. Tupan, in the course of his interview. Even if you find that either that should not have been left with the jury as potentially confirmatory or that the judge should have said something more about that, even if you find that one of those two things applies and that there was an error, then we say, nevertheless, even on that basis, applying Sanderson, there's tons of other evidence that goes to the potential confirmatory, the potential confirmation of the Vetrovic witness's credibility. And because of that, following Sanderson, you ought not to interfere with the jury's verdict. I mean, really, we say it was the appellant's words and his actions that led to his conviction, not the words and actions of the learned trial judge. Very strong Crown case here, and we say that even if there is an error, there's no reason to intervene. Now,
I asked Ms. Wiebe this. I take it as well from the judge's comments that there was a lot of evidence about the offense as opposed to Mr. Labossière's involvement in the offense that would have confirmed what Mr. Tupan said about how the killing was carried out and the house burning, et cetera. Is that correct?
Yes. Yeah, and that actually leads me to the discussion of materiality, and I won't take up much time on that. I believe the suggestion is that even if you don't have to have evidence that directly corroborates the accused's actual involvement in the case, you need to be looking for something pretty close to that. And we say respectfully that just simply isn't the law. And the Supreme Court dealt explicitly with this issue in a case called Kaler, not Kayla, but Kaler. It didn't make its way into the Book of Authorities.
We've all got it, Mr. Carter.
We do.
Yeah.
And so I'll just refer the court to paragraphs 12 through 16 of the Supreme Court's decision in that case. The appellant argues that the only relevant aspect of the Vetrovic witness's evidence relates to the implication of the appellant in the offense. He contends that the legal test applied contextually, that is to say, what he's referring to is the word relevant, in the word relevant aspects of the witness's testimony, that relevant here requires confirmatory evidence implicating the appellant. Nothing less, he says, could rationally restore the trier's faith in the relevant aspects of Mr. Greenwood's account. The Supreme Court holds explicitly the appellant wrongly equates relevant with disputed. Mr. Greenwood's detailed account of the robbery, though undisputed, was no less relevant to the offences charged than his implication of the appellant in their commission, and while confirmatory evidence should be capable of restoring the trier's faith in relevant aspects of the witness's account, it hardly follows that the confirmatory evidence must, as a matter of law, implicate the accused, where the only disputed issue at trial is whether the accused was a participant in the crimes alleged. In other words, just evidence about how the offense was carried out, if it matches, is, in this sense, capable of confirming the Vetrovic witness's evidence that not only was it carried out this way, but he's the guy who asked me to do it. There is no
Well, it
separate
can
rule.
confirm his evidence generally, and then you can accept when he says that Labossière was there. I mean, if it has nothing to do with Labossière, then it doesn't really confirm he was there unless you accept the Vetrovic witness's credibility.
Yeah, yeah. Yeah, I think that, I mean, technically that's right. Although, again, we think some of the evidence in this case went far beyond simply being confirmatory and actually pointed directly to the appellant's involvement in the case.
That being all the statements.
Yeah.
Yeah.
Well, the statements and the conduct, right? Trying to buy everybody out and producing a second will. And I should say in closing that we disagree with the suggestion that you ought to construe materiality in the sense of confirmatory evidence with similar fact evidence. That we think that's just the wrong road to go down. Really what you're talking about here is the general sort of corroboration of any witness's testimony. This is really an issue of credibility. It's not a question of whether evidence should be allowed to get to the jury or not. It has to do with what can you point the jury to in order to assist them in finding that evidence is credible or isn't credible. And so in that sense, all of the matters pointed to by the learned trial judge, we say definitely meet that threshold. And again, even if you disagree, we rely once again on the curative proviso. So even if there was a reference to some piece of evidence in the charge that we say, or the judge said was material and you think was not material, the overall impact of all of the evidence in this case, including not only Mr. Tupan's evidence, but the many unchallenged, unaddressed comments attributed directly to the appellant and his conduct, also left unexplained. The overall impact of that was extraordinarily damning, and that the jury's decision to find him guilty would not have changed with the sort of minor tinkering with the charge that you're being asked to contemplate. Unless the court has questions about the other ground of appeal, that is to say the introduction of the other material, I can follow my learned friend's lead and leave that with the court. But if you do have any questions about that, I'd be happy to answer them.
All right, thank you, Mr. Koffler. Brief reply, Ms. Wiebe.
The only two things I wanted to indicate was that her ladyship and my learned friend engaged in a little bit of a discussion about the facts that were actually on the record with respect to what the Vetrovic witness saw from the statements of Dan Labossière. And I know her ladyship pointed out the facts that Nicole Labossière Clark had adopted from Brian Brisson's statement. I just wanted to point out to the court that with respect to the evidence of Dan Labossière, volume 6, page 71, lines 2 to 5, the question was put to Mr. Tupan, and you're aware of his comments, and this is, I should start actually at the top of the next, or the bottom of the next page. So you get to hear Daniel Labossière's theory again that Jérôme tried to convince you to commit the murder. Is that right? Me and Mitch, yes. And you're aware of his comments about his theories about money and how that money was used to purchase the house that you bought. Is that right? So that's another distinct fact I think that the court needs to look at, is that, of course, Daniel Labossière gave this evidence in his statement that the money was used to purchase the house, and that's, of course, something that comes out in Tupan's evidence as well, is that the money from Labossière was used to purchase the house. And then similarly at volume 5, page 46, this is now Mr. Daniel Labossière's cross-examination, and he's talking about an interaction with Andre Tupan, where he says that Mr. Tupan is being cocky and that sort of thing, and in any event, Mr. Labossière tells him, I told Andre, I said, whatever he promised you, it ain't going to happen. I said, if he promised you big loads of money, I said he's not getting the farm. So I would suggest that that certainly leads to the inference that Daniel Labossiere's theory of the crime had to do with Jérôme Labossière taking control of the farm or ascertaining control of the farm. And of course, Mr. Tupen acknowledged many times in his evidence that he had been made aware of Daniel Labossiere's theories. So certainly that adds some more specificity to that point. The only other point I wanted to make very briefly was...
Sorry, just before you leave that, that comment was made to Andre Tupen.
He describes a conversation with Andre Tupen, who is Jeremy Tupen's brother.
Right. But the comment wasn't made to Jeremy Tupen.
Well, no, what I'm saying with that is that that conversation with Andre Tupen demonstrates that Daniel Labossiere's theory of the case was that this had been done in order to gain control of the farm. And Jeremy Tupen acknowledged many times in his evidence that he had been made aware of the theories of Daniel Labossière. And so I think the inference there is that he had been made aware of Daniel Labossiere's theory that this was done to get control of the family farm.
Thank you. Thank you.
Finally, my friend talked a lot about the Ontario Court of Appeal, the lines of authority there, saying that Sanderson is potentially in conflict with them. And in fact, the Chief Justice asked whether Kayla may have overtaken Sanderson. And I say the critical factual distinction between Kayla, Boyce, and Sanderson in this case is, of course, that in Kayla, in Boyce, in Burek, the trial judge never held out the potentially tainted evidence as being confirmatory. That's the critical distinction, and I cannot stress that enough. The distinction there was that the trial judge in those cases said there's an allegation of taint, you decide, which is the proper procedure in a situation where there's an allegation, not a demonstrated possibility of taint. That's the distinction, and so I say Sanderson and the case before you are very different than Kayla and Boyce, and so Sanderson still applies to the case before you. And in fact, in Kayla, paragraph 62, and I know your ladyship, you already made this distinction, but the court says very plainly in Kayla that the trial judge should have outlined the credibility differences. The court certainly was not endorsing the fact that the judge didn't charge on independence. They said they should have better recognized the fact that the need for independence should have been put to the jury, but in the circumstances, there were other elements of the charge that sufficed. Look at those other elements of the charge because they're way more specific than what you have here. And that's the only thing that saved Kayla. Thank you. Those are my only submissions.
All right. Thank you, Ms. Weeb.
So I'm going to take a quick look through my notes to see if there's any other questions for Codler, because I think you answered my question, Mr. Codler. Just to be sure, though, I'd ask the question, Ms. Weeb, of whether evidence of motive, taken apart from anything that was said to Tupen, but if Tupen said nothing about motive, says, I don't know what the guy's motive was, but he hired me to kill his parents.
Yes.
And you've got evidence of motive from the family members that connects Labossière. My question was that's clearly circumstantial evidence of guilt, but is it independent evidence that's capable of supporting Tupen's evidence that Labossière was involved?
Yeah, we say unquestionably that it is, milady. The law is clear that any evidence that is material can be confirmatory. We take that to be the touchstone of this court's decision in Ponce and Tavares, that the important words are relevant and important. So, is evidence of motive relevant in the case of a homicide where one person says, this guy told me to do it, and now you have somebody else who can say, this is why? Clearly, it's relevant. Is it important? of course it's important because it explains why. And the way the case law has developed in this regard, we say away from requiring sort of specific confirmation of the accused's involvement and towards generally anything that will give the trier of fact comfort that the Vetrovic witness is telling the truth meets the materiality threshold. In other words, if it's relevant and if it's important, then it's material. And evidence of motive, absent any overlap whatsoever. In fact, I think you could probably say that if Mr. Tupan had said nothing at all about motive, this appeal might actually be a lot simpler because we'd only be talking about one issue as opposed to two issues. But had he said nothing about motive, we say unquestionably that evidence from everybody else about motive would have been highly material and therefore would have met the requirements for confirmatory evidence within CALA.
All right.
I'm sorry, I just have to say one more thing, just in response to what my friend just said. I'm looking at Ponce and Tavares. I'm looking at paragraph 74.d, where this court sets out the requirements for confirmatory evidence. And the requirement is not that the evidence be important and relevant to the case. This court is very clear that the evidence has to be important and it must relate to an important and relevant aspect of the witness's testimony. That's the critical distinction that I was trying to make earlier. A lot of this evidence that was highlighted as being confirmatory is relevant and important to the case. That doesn't make it relevant and important to an aspect of the witness's testimony. And that's the critical distinction that I think needs to be appreciated.
Referring to which paragraph of Ponce?
74.
74?
74 lists elements A, B, C, and D with respect to the characteristics of confirmatory evidence, and specifically point D under paragraph 74.
Could you not argue, though, that it's relevant to a specific aspect in that Mr. Tupan has said, Labossière gave me the instructions. So the motive evidence relates to, I guess, whether Labossière was likely to have given him instructions, i.e., if you have a motive, it's more likely that he's involved than if there is no motive. That's a question, I guess.
Yes, my lady, we sort of got into this when you asked me the same question that you just put to my friend.
Okay.
I suppose if you take steps back and back and back, you can say that this could be used to generate an inference that could lead to this possibility. But when the requirement is that you're confirming relevant and important parts of the witness's testimony, it goes without saying that he's saying Labossière told him to do this. Does the fact that Labossière may have had a motive to do it give us confidence that he's telling the truth about that? I say with respect that it doesn't. And that's sort of the standard you have to look at.
And we would simply say,
Well, I've lost control. But my colleague asked a question, so I'll let you finish off.
thank you. And we would simply say, the accused hired me to do it is a relevant and important aspect of the witness's testimony and evidence that supports the proposition that the accused hired me to do the offense, whether it's evidence of motive or some other sort of evidence, definitely meets that standard and therefore is confirmatory.
All right, thank you. It will come as no surprise to anybody here that we will be reserving our decision. Pursuant to our guidelines here at the Court of Appeal, our task is to get these decisions out within a 6-month period, and we fully anticipate that that will occur in this case as well. I want to thank counsel again. Good afternoon.
Thank you.
Thank you.